how an HOA governs its members. The first way that an HOA governs its members is through the CC&Rs, or otherwise known as the declaration. This is the main document that is recorded when an HOA or a community association is formed. It is the document that Arizona law considers the contract between the members. Contract principles apply to this document. When you purchase a home in a homeowners association, by accepting ownership of that property, you become effectively a signatory of that contract, the CC&Rs. The next way that an HOA governs its members is through bylaws. Bylaws are considered a quote unquote living document that is amended from time to time by the association. And it generally explains how restrictions are enforced that arise out of the CC&Rs. So for instance, the CC&Rs may dictate that the common elements may be used by any member of the association, right? So if you have a community pool or a gym or a golf course or whatever it may be, the CC&Rs will give a right to the community to use those if you own property. The bylaws may be able to sort of regulate the details on how that usage may actually work in a practical sense. So if there's a community pool, the bylaws may dictate how access is granted to that pool, right? But the only reason the bylaws have any force and effect is because of rights granted to the members via the CC&Rs. There's sort of a hierarchy of bylaws. And so it's not a contract, but it is only able to create restrictions that are otherwise granted to it from the CC&Rs. And then in addition to the bylaws, you may also have rules and restrictions that are passed. And this is an even more specific document than the bylaws that is amended potentially on an even more regular basis to include very specific details of more general regulations that may be found in the CC&Rs. While the CC&Rs may say that members of the association have the right to use the common elements, the bylaws then say hypothetically that there may be restrictions on the ability to access these common elements through some sort of badge access. The rules and regulations can get even more specific about maybe the times that the pool is available to use, or things of that nature. And again, this is not considered a contract. This is simply regulatory authority that is granted to the homeowners association to allow it to manage the rights and use restrictions that are granted through the CC&Rs. And so I've got here the CC&Rs are the contract between the members in the association. The question from all of this becomes, at what point have you changed the nature of the CC&Rs? More importantly, at what point in the amendment of CC&Rs have you actually changed the bargain that people who have purchased within that community agreed to by accepting those regulations? Let's say instead of CC&Rs, we have a lease for a commercial building, right? So the office space that many of you are sitting in right now in Scottsdale, we have an agreement with our landlord to pay a certain amount in rent. We have an agreement with our landlord for certain amenities like a gym, things like that. And that is all codified in a lease agreement, which is also a contract. And there are certain things that the landlord may have flexibility on in terms of its things that it can do in its role as managing the building and the amenities that are offered and things like that. But that flexibility isn't unlimited, right? If the landlord comes in and all of a sudden raises our rent by 500%, or all of a sudden decides to just close the gym that's in the building and doesn't offer that anymore, to what extent do these changes actually modify the basis of the agreement we had in the first place, right? A modification of rent is going to be an obvious answer. Of course, that is a material term that we relied on when we entered into that contract. If you change that term, that changes the very agreement that we entered into, right? And so the same principle applies for CC&Rs. The fact that CC&Rs are a contract, and if you change a contract, even through a provision that allows for amendment, right? Because in all CC&Rs, there will be amendment provisions that say that the association, through whatever the voting mechanism might be, regulations can be changed by a majority vote or a supermajority vote or things of that nature. That power only goes so far. If you change the very nature of the contract or the bargain between the parties, you have effectively a new contract. And when you have a new contract, even though it's been amended, you then need to get the permission of all the parties, not just a majority or a supermajority. All of that leads to the question, how do we know if a CC&R amendment is valid? So let's talk about it. Arizona courts have weighed in. I'm going to start with what was, up until 2022, the seminal case on an HOA's authority to amend CC&Rs, Dreamland Villa Community Club versus Ramey. The first rule that came out of this Dreamland case is that deed restrictions, which in this case, if for our purposes are CC&Rs, constitute a contract between the subdivision's property owners as a whole and the individual lot owners. What the court went on to say in this case was that by accepting a deed subject to deed restrictions, a grantee assents to such restrictions and is bound by them. That when you purchase a property in a community with an HOA that has restrictions, covenants and restrictions, or it could just frankly just be deed restrictions included on the deed themselves, that does constitute a contract between the various owners that are parties to those restrictions. The next rule is that substantial restrictions must be incorporated into the CC&Rs. We have this standard of substantial restrictions need to be incorporated into CC&Rs and cannot be passed simply through bylaws or rules and regulations. Rule number 3, even if the declaration can be amended, the community must retain similar character. So without getting into too much detail, in this particular case, the issue was with regard to a fitness center that was offered to some members and not others, and then they made the membership to the fitness center mandatory. And it's like, okay, at what point have you changed the character of that community? Where at one point you could just live without mandatory dues, and all of a sudden now you are paying mandatory dues. Have you changed the character of that community? And so the court came in and said, look, yeah, the CC&R say you can amend to add new restrictions, but it has to stay the same kind of community. You can't change the character of the community. So when the lot owners originally bought, they came into a small residential neighborhood with public roads, no common areas, and no amenities, only to be subsequently burdened with broad assessments for safety, welfare, recreation, health, common benefit, and enjoyment of the residents of the lots. And essentially what the court came down and said is you can't do that. You can't go from basically having no common elements, responsibilities as it relates to those things, to having this comprehensive scheme that requires a whole bunch of additional cost. You can't just foist that on existing homeowners. You're changing the bargain, right? So, all right. So that was what had come out of the rules that had come out of Dreamland and was in place for nearly 12 years as sort of the law of the land on amendments to CC&Rs.